Hi all. I'm Shahrukh Alam. I'm practice at the Supreme Court, and I'm very often late. I'm very sorry about that. There was this poet, very eminent poet of Urdu, Jagannath Azad, and he was from Lahore, and he was quite the shining light of the literary scene in Lahore. And then he had to come to Delhi after partition. And there's a story about him that soon after partition, he was invited back to Lahore for a mushaira. And he went back, and Lahore had been his city, and he had been the one organizing mushairas in Lahore. But when he went back, he was being introduced by some novice. And he wrote a very poignant शेर then. He said, मैं अपने घर में आया हूँ, मगर अंदाज तो देखो कि अपने आप को मानिंद मेहमा लेके आया हूँ. So when Namita asked me to come here to CPR, to the Land Rights Initiative and to the Legal History Speakers series and to introduce her, this is what I was reminded of. Well, this is Namita Wahi, senior fellow of the center and founding director of Land Rights Initiative. And it's really the legal history speaker series is really her brainchild. And I've been watching it online and I've been really enjoying watching it online. And one thing that struck me is how I think the point that you're making is using legal history methodology to make the larger point that even while we're talking so much about decolonization, we're living in very colonized contexts. We're living in a particular dynamic of power that is a spillover from colonial times. So I really look forward to this. But there's one other thought that had struck me when you sent me the title of your talk today, how property saved democracy in India. There are two um, clips that have gone quite viral that I was immediately reminded of. When you say how property saved democracy in India, I don't know if you've seen on Twitter, this was part of the BJP's campaign in Jharkhand. And the clip involves a upper middle class Savarna family in Jharkhand. And they're sitting in their house and having their dinner, and suddenly the bell rings. And at the door are swarms of very visibly Muslim underclad families who just run into their house and take over their property. And then the campaign slogan is be careful who you bring in. If you want to save your property, be mindful who you bring in a democratic context. And the other thing that's gone viral, of course, is the New Zealand Parliament clip where they're bringing in that bill which redraws the terms of the original treaty with the Maoris, again about land, and how she then asserts herself. She does a haka in Parliament, and so the bringing in of cultural rights in an interplay between land and democratic rights and all of that. So I had some thoughts, but these are the two things that I was immediately reminded of. And I let you have the floor now, and we'll come back to this later. Thank you, Namita. Before you start, somebody had promised me coffee as I came in. Thank you.
Good afternoon, everyone. Thank you, Shahrukh, for agreeing to come and moderate this talk. And, I've known Shahrukh a long time. She was my senior in law school. And I think that today we are celebrating, as part of this series, the Land Rights Initiative's 10th anniversary. And I couldn't think of another person who has the kind of empathy and imagination and uplifting discourse as Shahrukh does in all her writings, and of course, her span of work as well to moderate this talk, which, is about a subject that really is where I began my journey on land rights. So we're celebrating 10 years of the Land Rights Initiative, but this is where I started 15 years ago. And it is a saga, a long saga in which there has been recently a new episode, and that's why I thought it was important to talk about these issues today. Yeah, thank you. So first of all, how do we understand property? Because property has many meanings, and it is understood by different disciplines in a different way. So in this particular talk, I'm engaging the insights of lawyers, economists, and political theorists, and they all understand property, and constitutional law theorists as well, and they all understand property a little bit differently. So just for conceptual clarity, lawyers understand property as a bundle of rights, which include the rights of use, possession, title, transfer, mortgage, inheritance, and lease. And their understanding is that these rights can be configured in the bundle in different ways, and each of them is a property right. Whereas economists tend to treat only title or ownership as property, and not the other rights as property rights. Now, the entire foundation of liberal political theory, attributed to Thomas Hobbes and John Locke, property or ownership is in liberal political theory of this strand constitutive of individuality, freedom, and equality. Because the idea is that in the state of nature, we all exist as individuals. To be an individual means that we are an owner of our own person and capacities, as opposed to, say, somebody who is a slave. Although some of these theorists did also justify slavery, but the idea is that you are the owner of your own person and capacities, and also what one acquires through the use of those capacities. Freedom, therefore, means independence from others, and independence arises from the right to use one's property. Equality, too, here is linked to ownership, because if you are the owner of your person and capacities, this is a status that in the state of nature, every individual enjoys equally, right? So liberty, equality, and property are therefore derivative in some way from the property or ownership, which is constitutive of being an individual, which is what liberal rights are about. On the other hand, the critical tradition, starting from Rousseau and then to Marx, has decried the illegitimacy of the social contract and subscribed to the view that liberty and equality, when we articulate them as rights, they basically protect property. So both Rousseau and Marx critique the idea of the liberal individual as an individual monad. They said this is not really what human beings are about. According to Marx, man is a species being, and from this conception arose the idea of the social function of property. Rousseau understood property as a relational thing created through an illegitimate social contract that preserved inequalities, as opposed to being derived from the state of nature. Whereas Marx critiqued liberal rights as not emanating from a state of nature, but as a result of historical struggle against privileges that were bequeathed from one generation to another. What that then means, according to Marx, is that the practical application of the right to liberty is the right of private property. And the right to property is really the right to self-interest or selfish interest, right? And the right to equality is the equal right to liberty. So equality protects liberty and liberty protects property. And therefore, the critique of this idea that we as individuals, that property is constitutive of individuality, is completely delegitimized in the critical tradition. So these are the two sort of dominant understandings of property within liberal political theory and critical social theory. Now we come to economic development discourse to understand the relationship between property and economic development. So the very idea that we can do something like economic development as an agenda that we can pursue is something which is a product of the post-World War period. Before that, nobody was really talking about economic development. It coincided with decolonization starting from the 1950s. This idea that, if we were to do certain things a certain way, then we can bring the emerging colonies who are emerging out of colonial rule and to the point that Shah Rukh made about decolonization, that is a very important part of our reality. So the idea of development theorists was that, yes, you can bring about development. Development has to be planned by the state. That was the dominant development discourse. And what they understood development as essentially was poverty alleviation and raising the standards of living of the people, right? And what were the ways of doing it? So starting from W. Rostow and other theorists of the time, like the Raoul Prebisch Singer hypothesis and so on, all these theories, capital formation and the associated concepts of planned industrialization, big push and balanced growth dominated discussions in development theory. Focus on land was tangential, like the way to really bring about development was this way. But yes, many theorists talked about land reforms, but there was no focus on property rights because everything had to be planned. And the Soviet Union was really the example there, the planned economy idea. And this was followed by many developing countries, including India. On land reforms, there were divergent views. There was Alexander Chayanov, who was a Soviet economist, and he believed that small farms were more productive. On the other hand, there was Alfred Marshall, who said that the small farms are not so productive because there will be no incentive to invest to make them productive. So we should so they had a different view on property rights with respect to land reforms. But there was no such view that like focusing on property rights is a way to development because the state was going to bring about development, right? This has shifted from the 1980s to the present, where we have people starting from the New Institutional Economics School, led by Douglas North, Barry Weingast. It's a program of lawyers, economists, and social scientists who have offered a variety of arguments on behalf of the need for formal property rights to promote growth. And then we also have Hernando de Soto, who wrote his book called The Mystery of Capital, highly influential, which spoke about how strong, secure property rights are a necessary precondition for economic growth. Not just that they can influence, but there is a precondition. And the reason why this has been in the news more recently, you were referring to some examples of property that have been in the news. What has been in the news is the 2024 Nobel Prize winners, AJR, Daniel Acemoglu, Simon Johnson, James Robinson. And their work essentially shows that inclusive institutions and democracy are again essential for economic growth. But their idea of inclusive institutions historically is that they have included secure property rights.
They have included
secure property rights, right? So suddenly, since the 1980s onward, there is a focus on property rights as being important, precondition, essential for economic development. And let's go back to the meaning of property rights that economists have. Secure property rights specifically mean ownership rights, right? So now, with this backdrop of the many meanings of property and why this is relevant to the discussions that we are having today, this is a legal history series, and the idea behind the series is to look at, how the past is influencing the present, because many of these questions we keep going on back to. One of those things that is, was a dead right at the time I went to law school. Nobody taught us about the right to property. So actually, I sometimes feel like a lot of my career has been about excavating dead things. But the original constitutional compromise that we adopted when we adopted the Constitution in 1950 involved a certain formulation of civil and political rights, fundamental rights, the rights to life, liberty, equality, and property. The Indian Constitution represented a commitment on behalf of we the people. So this is the first time after 250 years of colonial rule, right, that we have given to ourselves this constitution, a commitment to be governed by elected representatives according to the rule of law, and part 3 of the constitution guaranteed to all citizens these rights to life, liberty, equality, and property, right? And however, these rights were not unlimited. Like in the US Constitution, these were subject to reasonable restrictions in the public interest. Any law which, however, violated fundamental rights because they were enforceable would be unconstitutional. Now, if we look at part 4 of the Constitution, that talked about the non-enforceable directive principles of state policy. And remember, this is happening in a context, right? 1950. We have the adoption of the Universal Declaration on Human Rights in the mid-40s. The countries that are, really dominating the discourse at this point is the Soviet Union and the United States. And, this idea of the US Constitution, the more liberal focus as opposed to the focus on socialism and state-planned growth and things like that from the Soviet Union. So the Universal Declaration of Human Rights is adopted, and that is what is there in the back of the mind of the founders. In my work, I've talked about how much how excellently researched our constitution was in terms of studying the constitutions of all the different parts of the world that did have constitutions at the time. And we came up with a formula which we thought was going to serve the needs of our people. So the focus on distributive justice and social control comes in the directive principles of state policy, where it says that the state shall promote the welfare of the people by securing a social order in which justice, social, economic, and political shall inform all institutions of national life. That's Article 38. The state shall strive to minimize inequalities in income. It will strive to eliminate inequalities in status, facilities, and opportunities amongst individuals and groups. And this is important because the newest episode in this story, in the case that just was decided, the penultimate judgment of our Honorable Chief Justice D.Y. Chandrachud, is about Article 39, B and C, which say operation of the economic system should not result in concentration of wealth and means of production to the common detriment, and ownership and control of material resources of the community must be so distributed as best to subserve the common good. So essentially a focus on the social function of the state and social control of property. Because how do you reduce inequalities in wealth and how do you redistribute? You have to alter property arrangements. Now, these principles of state policy also included various rights to livelihood, to a minimum living wage. Men and women shall have the right to an adequate means of livelihood. There should be equal pay for equal work for men and women. And the state shall make effective provision for securing the rights to work, education, unemployment, old age sickness, disability assistance. Now, many of the rights that we have talked about recently, like the Right to Education Act, the right to health that is being, the Rajasthan has adopted the right to health. Where are these rights coming from in the Constitution? They are all coming from this commitment in the directive principles to provide this to the people of India. So now let's talk about property. So the fundamental right to property was the most debated provision in the Constituent Assembly. It is also the most amended provision, and it is also the only right to ever be abolished in the history of Indian constitutional law. So you can imagine that there's a lot of contention around this, right? The debate on the right to property started even before the terms of independence were worked out. So crucial was this issue. It lasted for 2.5 years. It came up with a compromise, which essentially nobody was really too happy about because it just led to continued contestation. And now we are back to the same thing. So what's really going on? What is this right? Why is it such a villain in the story, right? So Article 19(1)(f) is essentially giving all citizens the right to acquire, hold, and dispose of property. This was required because India did not have equality of status and opportunity at the time of independence. Women did not have the same rights as men with respect to ownership of property. Dalits were discriminated against. So this was a dignitarian right, giving everybody the dignity to hold and dispose of property. Remember, liberal political theory, property itself means that everyone has ownership of their own capacity. So this is a right about capacity. You're giving capacity to people who didn't have it before. Article 19(5), because our rights were not unlimited, the state can impose reasonable restrictions on the right to property in the public interest. And Article 31, this is the contentious provision, is essentially the law of eminent domain codified, which has essentially 3 requirements. The state, in the exercise of the state sovereignty, the state has 4 powers that are generally understood. One is the power to conduct foreign affairs. The second is the power of eminent domain, which is to take away property, including land, for a public purpose upon payment of compensation. The third is the power of taxation. And the fourth is what we call police powers, whereby the state can use even force and criminal law to enforce justice and police and regulate society, right? These are the 4 powers that are inherent in state sovereignty. This is about eminent domain, one of those powers. Now, Article 19(1)(f) and 31 basically guarantee justiciable property rights. The exceptions to justiciability were included because there was a big push on land reforms. And at the time that this was being drafted, we had the communists, we had the socialists who did not want there to be property rights at all. Nehru himself had come from within the Congress Socialist Party. And so there was a lot of debate and discussion. So essentially, they included 2 clauses which ousted judicial review of pending land reform legislation pertaining to abolition of zamindari tenures and excluded laws affecting property rights in the exercise of taxation and police powers, because eminent domain is different from taxation and police powers. Is everyone with me thus far? Yeah? Okay. So there were two discourses that framed the debate on the right to property. The first is the rights discourse. Now, what is the rights discourse? In a polity that was hitherto composed of British colonial masters and Indian subjects, the demand for basic rights against arbitrariness of the British rule dated back almost to the founding of the Congress, starting with the Home Rule Bill in 1895 and culminating in the Sapru Committee report of 1945, which essentially provided the blueprint for the fundamental rights that were adopted. The rights discourse is a dignitarian discourse because it is premised on the dignity of each individual to realize their full potential as human beings and equal citizens of newly independent India in a society which was deeply divided on the basis of caste, class, religion, ethnicity, and gender. So this is a dignitarian discourse. It is also a capacitative discourse, as we talked about in the understanding of liberal rights, is that everyone has the capacity to own not only themselves, but develop their capacities. So like if you deprives, for example, if Dalits are not allowed to access sources of water, then you are depriving them of their capacity. If they're not allowed to own, if women are not allowed to own property, even today, the Mapping Indian Land Laws project, we have laws where with respect to inheritance of agricultural property, there are still discriminatory provisions against women, against married daughters, unmarried daughters. So this is really the rights discourse is about capacitating people and respecting their dignity, right? And the second discourse is the development discourse. The development discourse focused on poverty alleviation and improvement of living conditions of all Indians, right? Development required a move, given the dominant in 1950s, I just mentioned that the dominant focus of the development discourse was planned industrialization, capital formation, urbanization. Development required a move from a feudal agrarian society to a capitalist industrial society through land reforms, state planning and control of heavy industry, and through encouragement of the growth of private industry. This was the development model that people were thinking about. Now, my claim is that the development discourse is a utilitarian discourse, which empowered the state to take coercive action against individuals and groups premised on the philosophy of the greatest good of the greatest number. When you have to lift people. So this is the essential conceptual clash between the rights discourse, which is premised on the dignity of each individual, and the development discourse, which is a utilitarian discourse, which is premised on the greatest good of the greatest number. The fundamental contradiction. Now, of course, I'm not claiming that, these were the overarching ideas of the rights discourse and the development discourse, but within these discourses, there were diverse opinions in the Constituent Assembly on what rights should be secured and how development should be achieved. These rights, were civil and political rights consistent with political liberalism to protect the citizen against arbitrary exercise of power by the state. Now, this idea of protection against arbitrary action was something which was supported by majority of the Congress leaders. Now, let us remember that in the Constituent Assembly, originally 70% of the delegates were from the Congress. After partition, when the Muslim League moved, 90% of the delegates were from the Congress. This is a Congress-dominated Constituent Assembly where all of these people have been to jail for protesting against British rule. So they're all agreed on the fact that the state should guarantee civil and political rights to protect citizens against arbitrary exercise of power. Nehru, Patel, Ambedkar, everyone supports this, right? Then we have social and economic rights, which are consistent with socialist thought and made imperative by the threat of radical communism, right? So there's the communists feel that this is all a rubbish exercise. We have to, there should be no constitution. We have to overthrow, and we have to, the people will rule as part of the communist state. China was becoming communist at this point of time, right? So the Congress socialists led by Nehru, the Communist Party of India from outside, and Ambedkar, they were all focused on social and economic rights. And many of these people were students of Harold Lasky, who had, at the LSE, which Shahrukh has actually studied, where she has actually studied. So you can maybe say more about this, but, he influenced the thinking of many of these people about how to actually achieve liberal rights of civil and political rights and social economic rights at the same time. And that's what they were working with. Finally, the focus on property rights came from zamindars and industrialists and many Congress leaders, including Sardar Patel and Rajendra Prasad, who believed in protecting in a more conservative approach of protecting property rights. And then finally, and this is my work where I sort of trace the emancipation from social subjection of what I call the bottom 60% of the population, that's women, Dalits, and Adivasis. Everybody's agreed on that, Nehru, Patel, Prasad, Ambedkar, and let us not forget our founding mothers of the Republic, the 13 women in the Constituent Assembly, Amrit Kaur, Durgabai Deshmukh, and others. Similarly, there's a diversity of thought on development. So state plan development focused on industrialization and capital formation is again a consensus amongst all Congress leaders except for Mahatma Gandhi, who of course is assassinated while the Constituent Assembly is still deliberating. He wants to focus on the villages. He does not agree with this state plan industrialization model. Then we have socialism, which is the Congress socialist led by Nehru. Land reform, the only consensus that exists in the assembly is that zamindari has to go. Why? And because zamindars were given rights illegitimately by the British, so that has to go, but there's no consensus on any other aspect within the Constituent Assembly. The debate rages on for 2.5 years. They don't really reach a consensus, and then they have to pass this clause, so they do. Finally, on Adivasis, they obviously recognize the unique relationship of the Adivasis with land, the fact that it is central to their community identity and culture. But the dominant Congress narrative, and remember 90% of the delegates are from the Congress, is focused on development through integration, as opposed to the British policy of identity-based isolation. And we talk about this in our scheduled areas report. But the tribal representatives, Jaipal Singh Munda, we just celebrated the birth anniversary of Birsa Munda, the 150th birth anniversary last week, and that the government of the day has declared that as Janjatiya Gaurav Divas. Jaipal Singh Munda, J.J. Nichols Roy, who basically were representing tribal communities, they wanted limited sovereignty or autonomy of tribal communities over the territory, but they were a minority voice, which was kind of not able to be that influential, right? Now, what happens is the partition of India and the institutional design which was created by the Constitution essentially allowed the Congress to become a dominant party. In 1946, as I said, 70% of the delegates. So the Constituent Assembly, if we think about it, has been the most representative place we've had in our entire history, except for the coalition eras that we have seen, because 70% of the delegates were from the Congress. Then, of course, post-partition, 90%. India then opts for a parliamentary system of government with a first-past-the-post system. And what is a dominant party? So in political science literature, a dominant party is one who exercises power for many terms and commands consistently large majorities of seats or votes. Political parties that have organized freedom struggles against colonial rule have often become dominant parties. The Indian National Congress was one of the first, but we saw that the South African National Congress, where again there's been a momentous election in South Africa for the first time. This dominant party of the freedom struggle was defeated in the recent elections, right? But for all these 30 years, they become dominant, right? Because they have brought the people together in this freedom struggle, and then the systems they adopt also favor them. So in the first three national elections held in 1952, 57, and 62, the Congress won 74%, 75%, and 73% of the seats in parliament. That's the kind of dominance. And in the 1967 general election, for the first time, their seat share falls dramatically to 54% and vote share to 41%, but seat share is still more than half, right? And in 1971, the Congress seat share in parliament once again rises to 68% and vote share increases to 43%. So they remain dominant for the first 30 years. And between the period of emergency, between 1975 to 1977, the Congress dominant party becomes authoritarian. So this is the backdrop in which this right to property has come up. And this is the framework. Now let's talk about development, right? Where were we at the time of independence? If you look at this graph, this shows India's population, which went from 350 million, which is the current population of the United States, to 1.3 billion today. So steady increase. Life expectancy was a mere 40%, average 40 years. Average life expectancy was only 40 years, pretty much. And at the time of independence, it is about 70 years now. So we have made rapid strides in many areas. Literacy rates have gone up 18% literacy rate. And for women and Adivasis and Dalits, this was 10% actually. So you can imagine what a enormous leap of faith it was to make all of these people, equal citizens, people who have a 10% literacy rate. And we have not made enough strides in literacy. We should have been 100% literate by now, but we have improved our literacy. This is the GDP. So our gross domestic product has increased considerably. The maximum increase has come post the 1990s. And its per capita income has also significantly increased. So the issue is that poverty to a great extent has been reduced, but and development expenditure as percentage of GDP has steadily increased. But again, we see a huge increase post the millennium because, and this of course corresponds with the GDP figures as well, because the more we have, the more we can invest in development. So, and yet, from the recent work of Piketty and Chancellor, we see that the share of the bottom 50% in the national income has actually, it was, it was, it has actually gone, yeah. Yeah, the red is the bottom 50%. So you see the red is the bottom 50% and the blue is the top 10%. So there was a period in the 70s when the top 10% went down, but it has steadily gone up. And actually the difference is now very high. So same with the top 1%. So the point that I'm trying to make with this thing is that while we have improved poverty, literacy, and so on, inequality has greatly increased, right? So against this backdrop, what was the conventional narrative about the right to property? What does property do to equality and what does property do to development? Now, the conventional narrative was that judicial enforcement of property rights impedes distributive justice. There's a clash between property and the goals of the directive principles, because those who lack property or who have experienced deprivation of their property entitlements are not able to look after their basic social and economic needs. And social redistribution programs. You cannot have redistribution without altering property, because that's what redistribution is. So like land reforms or other reforms, like bank nationalization, so on, inevitably seek to alter existing property arrangements. So if those are our goals as a society, then property rights interfere with those goals. As a result of this, every time there was a decision by the Supreme Court that the Congress government did not like, they said that the fundamental right to property has blocked the uplift of the poor. There was a narrative about how the court was reactionary and pro-property rights, and it impeded land reforms introduced by progressive parliament. The focus of this case was Kameshwar Singh. Now, remember, Kameshwar Singh was also in the Constituent Assembly. He was a Maharaja. He was the biggest zamindar in Bihar. And after the land reform laws of Bihar, United Provinces, which later became Uttar Pradesh, and the central provinces, which became Madhya Pradesh, when those laws were pending already while the Constituent Assembly was being drafted, and that clause where they said that, laws that are pending, their judicial review will be ousted, were really about these laws, even though they were not mentioned by name. But these laws were passed, and the zamindars went to court because they had the rights to property. And the court found the High Court first found the Bihar land laws unconstitutional for violating the right to equality, not property. There was no reference in the Bihar High Court, the Patna High Court judgment, to the social economic rights in the DPSP. Sir, can you please put the phone on silent? Yeah. Despite express of justiciability of land reform laws under Article 31(4), Patna High Court found that the graduated scale of compensation in relation to the size of land holdings set up an unreasonably discriminatory classification under Article 14, which is the right to equality. Simultaneously, however, the United Provinces, the Allahabad High Court, upheld the land reform law. It held requirements of compensation and public purpose must be read in light of the non-enforceable social and economic rights with respect to preventing concentration of wealth and reducing social inequalities, securing workers a living wage, and organization of village self-governance structures. So on the same, there were two different laws, two different judgments. Both cases went to the Supreme Court. The government of the day could have waited for the Supreme Court to decide, but it didn't. Instead, what it did was it went ahead and amended the constitution. It created a black hole called the Ninth Schedule, and it inserted Articles 31A and 31B, which essentially ousted judicial review of all land reform laws on grounds of violating fundamental rights. And then whatever laws the government, apart from land reform laws, they would also insert laws in the Ninth Schedule on grounds of violating fundamental rights. So whatever laws they wanted to insert, and remember, there are dominant parties. So whatever they want to insert, they can do that. And they inserted 11 land reform laws in the 9th schedule, including the Bihar and UP laws. The Supreme Court, however, the Bihar law was so problematic from an arbitrariness standpoint, the Supreme Court, despite the exclusion of their review, went ahead and invalidated 2 provisions of the Bihar land reforms law, and it upheld the UP and MP laws as the high courts had done. And in subsequent land reform cases, the Supreme Court upheld all land reform laws on grounds that Article 31B and 31A had ousted justiciability of fundamental rights. Basically, the court, so then why is there this narrative that the parliament was progressive and the court was reactionary? If the court was upholding all the land reform laws, then, why is this the case that the court is being reactionary? And this was the narrative that was used again and again to actually amend the constitution in response to whatever decision where the court questioned the government, right? Now, this is how it went. The First Amendment, remember, this is the First Amendment is passed even before the first general election has been held. So the Constituent Assembly, which was sitting as a provisional parliament, went ahead and ousted the judicial review of Zamindari abolition laws and introduced the 9th schedule. The Fourth Amendment then ousted the judicial review of the adequacy of compensation. This was in 1955. 17th Amendment amended the definition of estate in Article 31A, because in the Constituent Assembly, there was no consensus on beyond Zamindari. Now, in the second phase of land reforms, they wanted to acquire Rayatwari estates also. So obviously, again, the question went, and like I said, the only consensus had been on Zamindari. So again, Justice Subbarao and, in his judgments, they were testing the laws on questions of arbitrariness. Wherever the court passed a judgment the government didn't like, they went ahead and amended the constitution. Same with the 25th Amendment, which replaced the word compensation with the word amount. Basically, the government wanted no scrutiny of their laws. And finally, the 44th Amendment made the fundamental right to property non-justiciable. Now, so entrenched was this narrative about property that even though most of those amendments were passed by Congress governments, the 44th Amendment, which deleted the right to property, is actually the Janata Party government, who had actually ran the entire campaign against the Congress government. But basically, everyone in government agreed that the right to property has to go. They introduced Article 300A, where essentially it only said no person shall be deprived of his property without a valid law. But they took away the requirements of public purpose and compensation so that the court cannot get into it, right? And, so they reversed the original constitutional compromise from 1950 to 1978. Following the bank nationalization case, R.C. Cooper, Parliament passed the 25th Amendment Act that inserted Article 31C into the Constitution. That article is what came up in the Supreme Court judgment recently. That Article 31C, so 31A and 31B had been passed in 1951. 31C essentially said that all laws that further the goals of Articles 39B and C, and 39B is that the material resources of the community must be distributed so as to best subserve the common good, and government must work in order to reduce inequalities in income and wealth. So any law that furthers this should not be scrutinized on grounds of fundamental rights. Following the 44th Constitutional Amendment, right to property doesn't remain anyway, so Article 31C was amended to say that, only liberty and equality. This essentially reversed the original constitutional compromise. Following this amendment, Indira Gandhi-led Congress-I government swept to power in 1971 on populist slogans of Garibi Hatao and nationalization of industrial and financial assets. Because in the bank nationalization case, the Supreme Court had again struck down the bank nationalization for being arbitrary. Then what we have is that post the millennium, starting from this neoliberal economic development discourse from Fernando de Soto, that strong formal property rights are critical to unlocking capital, the World Bank finance programs for formalization of property rights and creation of a land titling system. Our government is now focused on these kinds of programs, starting with the Land Titling Bill of 2010, which never got which never got enacted, the Digital Land Records Modernization Program of 2008, the recent Swamitwa scheme, which is about distributing property cards to beneficiaries in rural areas. This is where the discourse has shifted and government policy today has shifted. So simultaneously, social movements like the Ekta Parishad have critiqued state acquisition of land and have sought land rights of the poor and landless communities. So So both the economists and the communities are seeking better protection of land property rights. Social movements have argued that widespread land acquisition by the state has dispossessed poor peasants and traditional communities like forest dwellers, cattle grazers, indigenous fishermen, and tribals. The Forest Rights Act was adopted in 2006 to protect individual and community rights, property rights, I would call them, because they are really about rights to basically be in the forest and exercise the rights that they have had for hundreds of years, except when they were taken away by the forest laws that were passed by the British and continued by the Indian state. Scholars are now suggesting that the weakening of property rights by Parliament in response to the court's property rights decisions has in fact dispossessed the poor, and as the economic data shows, it has actually led to greater inequality between the rich and the poor. So the Supreme Court, starting 2000, has made the right to property justiciable again through creative judicial interpretation. Enactment of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act is another development. In 2010, in Sanjeev Agarwal versus Union of India, they contested for the first time that the 44th Constitutional Amendment should go and the right to property should be reinstated because of massive and widespread displacement of poor people due to state-led projects of economic development. Supreme Court dismissed the petition on the time, but not on merits, indicating that it would be refiled in a more appropriate case. 15 years down the line, we have had, focused again on reinstating requirements of public purpose and compensation within Article 300A. And that brings us to the newest episode in this property rights saga, which happened last week. This was a petition by the Property Owners Association against the state of Maharashtra, which challenged Chapter 8A of the Maharashtra Housing and Area Development Act, which essentially allows the state, in case of very dilapidated buildings, that if 70% of the residents want it, then the state can go in and take over those buildings and hopefully fix them up. But it is coercive because the 30% people who don't want it, they have to be forced to do it. Now, contrast this with the land acquisition law that we had from 1894, where basically no consent was required for taking away land of the people, right? And even the new law has a 70%, even 2013 law has a 70% consent requirement. So this is a very parallel law to what we've have managed for land. Actually, we managed to have now in 2013. There was no consent requirement before for 120 years. Now, this is a momentous decision because it turns on the interpretation of whether material resources of the community in Article 39B included private property. And the reason this came about was that following the abolition of the right to property in a series of decisions in the 1980s, but more specifically for our purpose, this decision in 1982, the Sanjeev Coke Manufacturing Company versus Bharat Coking Coal, which was about nationalization of coal mines, the court had said that material resources of the community includes private property. So, writing for a 7:2 majority, Justice Chandrachud has held that no, there is a constitutional right to property in Article 300A, and directive principles cannot run counter to the constitutional right to property. And the materiality of a resource has to be evaluated in a case-by-case manner, and the considerations should be the nature of the resource and its inherent characteristics, the impact of the resource on the well-being of the community, the scarcity of the resource, and the consequences of such a resource being concentrated in the hands of private owners. And in this case, they made the assessment that the provision is unconstitutional, right? So that brings us to, how constitutional courts are operating. As I'm showing in this narrative, that this new judgment is basically finding problematic a law relating to urban property, and yet has pretty much, like in the Narmada Bachao Andolan case, for example, which happened in 2000, or many other cases where huge amounts of land have been taken over for, traditional communities, Adivasis, forest dwellers, had no issues with that because there in the Namita Wahi case, the right to development, like the right to drinking water of the millions in the cities and in the state, are given primacy. So, should there be judicial review of property rights? What did the Constituent Assembly say? The first group, led by Nehru, believed that the legislature should be the sole arbiter of compensation. So, tomorrow, if I decide 1 rupee per acre for land, that should be okay. That was the Nehruvian view. And the court has actually upheld those laws also post the right to property going. Samvanti versus State of Punjab, the court said 1 rupee per acre is also okay if the state thought it is okay. The second group, led by K.M. Munshi, who was a lawyer. Of course, many of them were lawyers, but he believed that the individual's right to property mandated that full compensation should be paid in all cases of compulsory acquisition. Courts, not the legislature, should be the final arbiters of adequacy. And the third group, led by Ambedkar, Patel, and Krishnamachari, took the middle ground, saying that while the requirements of full compensation and judicial review of adequacy should not apply in the case of zamindari abolition, like I said, the only consensus was on zamindari abolition, they should apply in other cases. There was only consensus that zamindari must go and industrial property be protected. And I think the point that I'm trying to highlight is that property doesn't mean the same thing to everyone in the same time. It means different things at different points in time. So when we talk about property, doing this and that, property bringing about economic development, first of all, we need to understand what that property is, and we need to understand where the development discourse is at that point in time. What happens in 1950 is that Patel dies, leaving Nehru as undisputed leader of the Congress party. So in the Constituent Assembly, there's a lack of consensus. But once Patel dies, Nehru is dominant. In 1951, therefore, when Nehru moves the First Amendment to the Constitution with Ambedkar's support, noting that the delays caused by litigation will delay land reforms, it passes because there isn't that kind of opposition. Later that year, when Parliament stalls the Hindu Code Bill, Ambedkar resigns from the Congress, right? So you see the bulwarks of discord within this view. There's Nehruvian view, Patel view, Ambedkar view, but Patel and Ambedkar are gone. So in 1952, Ambedkar, in fact, he's the one who's drafted the constitution, the chairman of the drafting committee. He's appearing on behalf of the UP Zamindars before the Supreme Court. And it's not because suddenly he develops a liking for the Zamindars, because he realizes that taking property without compensation in an arbitrary, I hope this is clear. So he's in the Constituent Assembly, he's saying that property should, other than Zamindars, everyone else should get full compensation. And then suddenly, why is he appearing in the Supreme Court in 1952? People don't know this. He appears on behalf of the UP Zamindars, saying that taking property without compensation in an arbitrary manner went against the spirit of the Constitution, because he sees what's happening. You know, when one party is the dominant party, and within that dominant party, if it becomes sort of taken, because the other leaders die or they leave the government because things are not happening, then, there is only one view that is happening. And when that one view that is happening can lead to arbitrariness, Ambedkar, being the staunch defender of rights and liberties that he actually was defending against his own constitution, the rights of the people. 1956, Ambedkar dies, leaving Nehru to define the legacy of the constitution. The right to property is amended 3 times before Nehru himself dies in 1964. Now, what happens in the late 60s is that in 1967, by a 7-6 majority, because the government is just going on amending, Parliament is just going on amending the constitution. So in the Golaknath case, the Supreme Court holds that, wait a minute, there are limits to your power of constitutional amendment. Parliament cannot abrogate fundamental rights. The constitution has been amended more than 17 times in 17 years. And it's not just property rights. They're amending the right to free speech. They're amending all kinds of fundamental rights. So in 1969, there is a split in the Congress between the Congress O and Congress R, which later becomes the Congress I. The Indira Gandhi-led Congress I remains in government with outside support of communists till 1971. During this period is when they passed the privy purses, abolished the privy purses and the nationalized banks. Through first an ordinance in 1968, and in 1970, the Supreme Court strikes down the ordinance as well as the subsequent law as being arbitrary and violative of the right to property, as well as the right to equality and so on. In 1970, they also, when Congress abolishes the privy purses through a constitutional amendment and fails because they don't have the numbers, they do it through a presidential order, right? And so therefore the Supreme Court strikes it down, saying that, you cannot amend the supreme law of the land, which is the constitution, through an executive order of the president. But elections are held in 1971. Congress again becomes a dominant party. Its vote share and seat share goes up. And in 1972, Indira Gandhi passes a series of constitutional amendments to overturn all these Supreme Court cases, Golaknath, bank nationalization, privy purses, and so on. In 1973, this then leads to the famous Keshwanand Bharti case, the basic structure case, where again the Supreme Court, in the highest bench strength it has ever sat on, comes up with a basic structure doctrine saying that there are limits to Parliament's amending power. That then leads to the declaration of emergency. And this is how a dominant party becomes authoritarian. Ultimately, emergency is called off, elections are held, the Janata Party government comes to power. They remove all the unlawful constitutional amendments that were passed during the emergency, but then they actually delete the right to property. So my revisionist account is of this right to property is based on a review of 377 Supreme Court and 1,239 High Court cases, a total database of 1,616 cases, which involved a challenge to the right to property. And my review shows that the Supreme Court and High Courts, in all of these cases, there is no such thing where the Supreme Court is disagreeing with the government on what is the way forward of the development path. They agree with the government that economic development and industrial growth is progress, and this is derived from the dominant development discourse of that time. The disagreement is arising in only two sets of cases. The first is fear of arbitrariness, where the court agrees with the broad scheme of social and economic welfare, but the provisions of the particular law are so arbitrary that they are worried that the way it will be implemented will lead to undue hardship. And therefore, they strike down the law. The right to property is always used with the right to liberty and equality in striking these laws. Second situation is where there is a consensus in parliament about the overall social goal, but there is no consensus about the particular measures for achieving that goal. Here, the court is essentially serving as a site for mediating tensions between the majoritarian will and the political opposition, which is completely ineffective in parliament because of the Congress being a dominant party. Whatever they want, they can pass through law. So the court is basically providing a safety, like a pressure cooker, like a pressure valve, because there's either opposition on the streets or it is in the courts. When we analyze these cases, if we look at the fundamental rights invoked to support the claims before the court, these are all the property cases. Article 19(1)(f), 14, and 31 are almost always used together. And that then brings us back to the original liberal understanding of property, that liberty, equality, and property in the liberal tradition are fused. And that is how the courts are also seeing a lot of these cases, that it's really about arbitrariness. Yes. Same with the High Court. The trends are exactly the same in the High Court. So we can't say that, we haven't looked at some cases or we've looked at all of them and this is how it is. When we look at the purpose of litigation, given that the entire conventional narrative about the Supreme Court being reactionary is based on land reforms, actually in the court's docket in both Supreme Court and High Court, land reforms is one of the biggest numbers. At the Supreme Court, it's actually at number 2, and at High Courts is number 1. But there are other instances where people are using the right to property to challenge taxation laws, land acquisition, and licensing religious property, nationalization or takeover of banks, inheritance and succession law, urban tenancy law, Essential Supplies and Commodities Act. A lot of these cases are really about the right to trade and business. They're also used together. 19(1)(g), and which is the right to trade and business, is used with the right to property. So what that leads us to understand is that because there is a right to property, they are using the right to property. So many of these cases actually are also about livelihoods. So this case, Sagir Ahmed versus State of UP, which I used in my work on demonetization to say why demonetization was unconstitutional, Sagir Ahmed actually used the right to property to include the right to livelihood. Now, all of us who are familiar with constitutional law will know that the court has now read right to livelihood as part of right to life. But before that, when right to property was there, right to livelihood was being read as part of right to property. Workers' bonus and wages, there are cases which the Supreme Court has decided where workers' bonus, which is the classic thing against property, which is the sort of Lochner idea that, the property rights were used against workers. The court has read the workers' rights to bonus and wages in property rights. So that brings me to conclusion. This work started out with a way to understand the role of constitutional courts in a democracy. And, the key insight that I think my work is trying to show is that while constitutional courts have often been critiqued as elitist, counter-majoritarian, ineffective, that critiques are based largely on constitutional experiences of certain countries like the United States. While it is true, my account shows is that actually courts can enhance democracy in a post-colonial state with a dominant party. So I'm very context specific, and that's the point I want to make. Property itself has a different meaning for lawyers, economists, political theorists. We have to be very context specific, as Justice Chandrachud says in his judgment. What in this particular, and this is why legal history and doing history is important, in this particular context, my work shows that courts can actually enhance democracy in a post-colonial context with the dominant party by providing a space not only to minority voices. Courts are often supposed to represent minority voices, but where a silent majority is unable to resist the agenda of the dominant party because the parliamentary system of government with a first past the post system and the ease of constitutional amendment doesn't allow those voices to have their say in parliament. That's where these tensions are mediated by the courts. And in all former British colonies, courts were playing this role throughout British rule when there was no representation of people in government. Institutional history and memory in high courts, which predate the constitution. So only the Supreme Court is from 1950, but the presidency high courts are from the 19th century, and they're used to this because the only recourse you had during colonial rule was to go to the courts. So that's what they have been doing throughout their history. The court interpretation of the right to property in India was less about property, entrenchment. It was more about rights and resistance against arbitrary state action. Whatever rights were included in the right to property, many of those rights have now been articulated through other rights like the right to life. In developing countries that are also constitutional democracies like India, the hegemonic development discourse almost always trumps the rights discourse. Narmada Bachao is the norm. Vedanta is always the exception in terms of the Supreme Court upholding the rights of the Adivasis and more marginalized groups. The development discourse, in its very understanding of what development means, privileges the urban over the rural and industry over agriculture. It privileges property rights of industry over those of poor peasants, forest dwellers, traditional fisherfolk, and other traditional communities. Justice Chandrachud may have reversed the original constitutional compromise that, no, the 44th Constitutional Amendment and the 25th Constitutional Amendment, which inserted Article 31C and deleted the right to property, may have reversed the original constitutional compromise. Justice Chandrachud's judgment has tried to reverse that reversal. But the truth is, when we talk about context, it is very clear that the judgment may have been very different. If it was not about property owners in Mumbai, but really about Adivasi groups in Odisha or Jharkhand or Chhattisgarh. Thank you.
Thank you. Thank you, Namita. That was rich and that was intense. And before I open the floor, I had a few thoughts of my own, if I may. You've touched upon all of this, but I just again wanted to reiterate. You're making the Congress party sound, or Nehru rather, sound a bit like a land snatcher. The Kashmiris would agree. And on this, the courts and parliament are one. But that's another. I'm saying that was a joke. I said that you'd rather making Nehru sound like a land snatcher. And I said that the Kashmiris might agree on this. And on this, the parliament and the courts are one. But
I'm not sure I've been calling him a land snatcher, but please go on.
That's partly a joke, but let me start from what my thoughts are. When you describe property from the perspective of lawyers and economists, I think it might also be useful to talk about property as a manifestation of political power, simply a power dynamic, and also simply a manifestation of neoliberal political power on the one hand, and then a counter-majoritarian pushback on the other, the pushback from the marginalities. And when I spoke about these two viral clips in the beginning, I think they represent either power block. The first, which is a Savarna family sitting at home having dinner, and then being stormed by poor, ugly, dirty Muslim families, is a very particular kind of manifestation of property as power. And that is more the neoliberal conception that you were talking about, where this family's individual rights, their civil political rights, are manifested in their right to secure their property and to enjoy their property to the exclusion of others, very specifically to the exclusion of others. And for them, the rule of law and democracy means exclusion of others. Whereas in the Maori example, it's exactly the other way around. The state is claiming land, the state is claiming Maori land, and the Maoris are saying, we will not give it to you. And so therefore that dance in parliament is the exact opposite. And I think that distinction, and you've made that already over and over again, but I think that's something to reiterate. And then again, in continuation, where you talk about the rights discourse versus the development discourse and how they were sort of um, at loggerheads, I again think that they're not. It's more a matter of how they're both framed. When the rights discourse is framed as a dignitarian right, and I was immediately reminded of ghettoization. The ghettoizations of Muslims in India today is basically about an attack on their dignity, right? It's to do with property, it's to do with pushing them out of civic spaces, but it's basically about an assault on dignity. And therefore, if you look at rights in dignitarian terms, and if you look at development in terms of redistribution, then they're very much part of the same narrative on the one hand. And on the other hand, if you look at rights as a matter of a Savarna family enjoying their meal to the exclusion of others, and and at development as economic development, as GDPs, then they're contrary to each other. But I think these are two narratives that may or may not go together. So the rights discourse is not necessarily contrarian to the development discourse. It's one narrative which frames both together, and then another narrative which can frame both together. The third point, and this is this is when I was joking about Nehru. You say that the Congress Party took off a bit, and they declared the courts to be reactionary, and the courts weren't really being reactionary, but the Parliament was overstepping its domain in continuously amending rights, continuously sort of overriding the rights of people, even if they were zamindars. So here, I think just the decision of the courts on these particular cases is a narrow view, no? I think that we also need to think about the question of diversity on the benches. And especially at the time of Kameshwar Singh, if you look at the demography of the Patna High Court, they were all zamindars, not so in UP. And some legal sociologies which have talked about this have also commented on the fact that the courts were reactionary because the benches were all especially in North India, from a certain class. And they were ruling a particular way because of that. Kameshwar Singh was ruled in a particular way, and it had the bench had a bearing on it. So that's one. And you've yourself said that when you're talking about how the courts deal with property, it's not just property. I would also consider how the courts have dealt with Article 370. What is their conception of property? What is their conception of land rights? What is their conception of ownership and territoriality? You can't be ruling about the way DYC has ruled on property in the Bombay context in one way and rule on 370 in a completely different way, or rule on the problem of refugees where you say we don't want refugees here, we don't have space for Rohingyas here, in a completely different way. Then you can't rule on CAA in a different way, because behind CAA is basically a paranoia of outsiders and pressure on land. And you've said that already. The courts can't be talking about tenancy rights, where you can summarily throw out tenants in a particular way. And finally, I mean, this is how you ended yourself, that this particular case where he restores the balance, the constitutional balance, so to say, emanates from a context where it's about property owners association. And what was being done was property was being taken away from them and given to homeless people, right? At the same time, the courts have nothing to say about builders taking over property or the Dharvi slums being taken over and not even being redeveloped. So the reactionary court and the authoritarian government, I would suggest that we need to also bring in more factors and review that a bit. And I had a last question for you before I end. You did talk about how the pro-property courts had actually an adverse effect on the poorest people. You did say that, no? That when the courts become pro-property and the parliament then becomes overly. Oh, you're okay, okay. But talk a bit about that. Talk a bit about that. Thank you. And should we take more questions? Or let's take one or two more questions from the floor and then we. Yes, please.
Please go ahead. Yeah. Anybody? Thank you, madam, for your. Just. My question was on that we have talked the government and the landlord property views. My question is that Jamidari in 1947, when people earned a lot of money, they used to invest in bigger lands, big chunk of lands. And later on, then they said after 10, 15 years, maybe 1950 or 60s, that you can't buy a bigger land. Now, the ownership of land, when you earn a lot of money, the ultimate target is not gold. It's only the property. You can go through any corporate, they are buying properties. Those who are flush with fund, they buy properties. And the government makes, certain rules for certain people, and for certain people, they make different rules. And they keep on buying, whether it's a property, government acquires property without giving any notice, just make a, advertisement, and then they acquire property. So that is also not a fundamental right. What you have to say in all these aspects?
We'll take one more.
Namita, thank you for such a rapid fire presentation from history to case law and constitutional process, especially for a graduate of political science, is a bit too much. But I would say there is a creative tension between part 3 and part 4. Part 3 being fundamental rights, they represent their liberal philosophy, and direct to principles a socialist philosophy. In any case, we were born with that tension. Don't you think it is natural and also right that popular will, you simply dismissed it as a majoritarian impulse? During all those controversies, the 50s, I mean, especially election, they became very unpopular in the media because of her bank nationalization and all that. But people gave her a thumbs up. So I would say it's a natural process, not that everything is good what the parliament does. It does excesses, just the way court did. But in terms of democracy, I would say I can put up with parliamentary excesses, not judicial, which is they have no accountability.
Namita, there's one related question to the one that I already asked, so I'll club this in. It says, what do you mean by property? Immovable, land, housing, financial, movable assets. Law relating to these differ. Are you assuming that property only means land? Your response.
I have about 10 questions, so if I don't remember all of them, try to answer all of them.
Yeah, ma'am. I question, ma'am.
Should we let her answer and then we'll come back to you?
Okay.
Yes.
Thank you, Shahrukh. Can you hear me? Yeah. Thank you, Shahrukh. So I don't really have anything to say about Kashmir or Article 370 because I don't know enough. I just want to clarify.
Those were rhetorical questions anyway. So
Yeah, okay. I just wanted to clarify. Professor Shambabu was right. I covered a lot of ground, and so there may be.
That was a compliment.
So just to clarify my position on a few things, there is no question that we need to have more diversity in our courts and in our representation. There is no question that I haven't talked about a majoritarian impulse. I've talked about majoritarian will or dominant will. Um, so, but what we need is protection against arbitrary state action. That was the original impulse behind the adoption of the fundamental rights. And that remains the impulse today as well behind the exercise of our rights. So the issue here is not the fact that the zamindars should have got full compensation. The issue really is about when Parliament ought to have acted to sort of enforce that view, because the Bihar law, which was struck down, and I think you are from Bihar, so it was apart from all the other reasons why I wanted you to moderate this talk, because this Kameshwar Singh case is really important, right? Because it is the fundamental tension where you have property owners, and let us not forget that the Constituent Assembly had a property, people who were eligible to vote for the Constituent Assembly, there was a property qualification. So it's not a surprise that you have these property owners dominating not just, the courts, but also in other places, right? But the issue with the Kameshwar Singh case is the vilification of the court for something that it didn't do. So let me explain that. There were three laws. There is the United Provinces law, the Bihar law, and you're right that perhaps the UP, this thing was different. But if you read the case judgments properly and carefully, you find that there was a difference in the laws themselves. The kind of arbitrariness that was there in the Bihar law was simply not there in the other two laws, which were upheld by the courts. And I must say, and I don't know if you would agree with me, but my own experience reviewing these judgments on, 1,000 judgments on property rights, the judgments on land acquisition, which we published as part of the land acquisition report, I personally find the government is the court is very differential to the government. So the times that it actually takes a stand against arbitrariness is when it is really a problematic law. Which is why the case, when it went up to the Supreme Court also, the Supreme Court actually did exclude two provisions, even though the judicial review has been urged.
What were those two provisions?
Yeah, I can show them on the slides as well. But essentially, in the Bihar law, there was a graduated scale of compensation, which in the judgment of the Patna High Court would have meant, and remember, Maharaja Adhiraj Kameshwar Singh was one type of zamindar, but the zamindari system also involves very small zamindars who actually did not have that big piece of land, which were also going to be liquidated, and there was no mechanism of check against that law. So it is the specific provision of that law, rather than this idea of protecting property rights. As I mentioned in my presentation, they did not strike it down on the right to property, they only struck it down on the right to equality. And I think there was a reason for that, and that is a consistent thread that we see, for example, in the judgment in it's Justice Subbarao's judgment on the Rayatwari tenures. It's like, or on the plantations of Kerala, because basically they had passed Rayatwari abolition, but they had excluded coffee, cardamom, and rubber, but they had not, for example, excluded other plantations. Same with bank nationalization. Why these 6 banks? Yes, they were the largest part of the sector, but then why not nationalize the entire sector? So these are just questions which a parliament that sort of respected institutional process would have been like, okay, this law has been struck down, we'll just pass another law remedying those defects. That is not done. What you constantly do is to oust judicial review through each amendment. You want no scrutiny whatsoever on your work. And I think that is the problematic thing. So, like I have been mentioning from the beginning, and thank you for all those examples that you shared, I'm absolutely convinced that the Dharavi case might not go the way this particular case. It could also, but the likelihood is more against it. In fact, we are actually working on a research project right now where we are studying when social movements use the law and when do they succeed. And we are studying the Vedanta case, the Narmada Bachao Andolan case, and a few other cases to see. And, when we interviewed, we recently returned, Anshu and I, from, this year we went to study the Vedanta case. We returned from the field. We interviewed the lawyers who brought those cases. And when you speak to people on the ground, even for Narmada Bachao, they say that actually, even though they lost that case, it was still a success because the development juggernaut is so intense that, they would have the very fact that their land was being delayed from loss. So this responds, sir, to your question as well. So, this also responds to your question about whether we do rights or not, because essentially, because the fundamental right to property was diluted, we have Article 308. But if you see the judgments post 1980s, and I'm not just talking about property rights judgments by the Supreme Court, like constitutional bench cases and all that. I'm talking about land acquisition, which is a statutory law under Article 31, which was still there. In those cases, there is absolute deference. The only time where the court is actually intervening, and not very often. So in our land acquisition report also, we show that the litigants are winning more often than not on compensation. But public purpose, for example, is being litigated only 1% of cases. So the court never questions the purpose for which the government has acquired. So already very differential. But when there is such injustice that, land, because, and the injustice is also arising because of what you're saying, right? Like these people, a lot of the litigation in the land acquisition report, for example, is coming from Punjab and Haryana, where they see this very rich farmland being acquired for a certain amount, and then it is used to set up malls and things like that. And the developers are making so much more money out of it. That's why these farmers are going to courts to get their amount. So I am not fixated on property rights. I do think that we need more rights.
You're talking more about arbitrariness of process.
Yeah. So,
Yeah.
and that's what I've tried
Yeah.
to show through a review of these cases, which has never been done before,
Hmm.
is that wherever they are disagreeing, it's really about arbitrariness, because the land reforms cases are only 20% of the total volume of cases. A lot of the cases are about misuse of taxation powers, which
Yeah.
of course we are familiar with today as well, and misuse of government powers of licensing. And what happens is that if your license is cancelled, your ability to do business is taken away completely. So a lot of these cases are actually about right to trade in business and also the right to property, because if your right to trade or business is taken away, what do you do with that property? Sagir Ahmed case was about nationalization of road transport in UP. This is a 1954 case. And basically the court was like, why did you pass the scheme in this way? Okay, you want to nationalize, we understand. You want to provide cheap road transport, right? Why didn't you just take away buy the buses of the people who were basically couldn't fly their buses anymore? Why couldn't you do this in a more dignified, humane way? I completely agree with you that I'm not saying that there is a contradiction inherently between development and rights. Both have influenced each other, because Amartya Sen's human capacities approach is a different understanding of development. But I'm talking about the dominant development discourse, which is focused on pushing people off the land. This is the gospel from the 1950s onwards. Push people off the land, make them more productive in industries, and there has to be capital formation. How do we push developing countries out of poverty? This was the formula. So the formula is utilitarian. There has been changes within that, and I'm not saying that Amartya Sen won the Nobel as well as AJR have won the Nobel right now. They are very different conceptions. So I'm not saying that this is a unified conception. I'm just saying the dominant discourse, and when I see it in the land policies of the government today, for example, what the focus is on, it's De Soto's work that is governing the policies, not necessarily Amartya Sen's, in the way that I see that land is being organized. So my limited point is that context matters. Both in the way we understand property. My point is that we need to have checks on arbitrary state action. And with due respect, I actually disagree with you, because, of course, majority will matters, but nowhere, no government in our history, including we had a party which was in majority on its own until from 2019 to 2024, with only 39% of the vote share, but also the Congress party, which is dominant during 1952 to 67, never got more than 44-45% of the vote share. The highest vote share it has ever got is 45%. So the fact of the matter is, it is never, if majority will is what you're talking about, none of our dominant parties, authoritarian parties, Indira Gandhi had even less of a vote share, and less seats in parliament compared to Nehru's government. And I don't really think that there is any the whole point, it is the dominant party's attack or sort of constant pushback against any questioning of its authority. And if you look at the people who were writing had a different narrative, because this is the dominant narrative, but Upendra Bakshi, Rajiv Dhawan, they were writing about the court, and Upendra Bakshi in his work, he talks about how the court, how this was not, again, they have the same view. They don't think that the court was acting on behalf of property interests. They say it was really a tussle for institutional power. But when I interviewed him more recently for my dissertation, when I started working on this book, he said Nehru was a modern prince. And he wanted to, of course, at his heart, he was a Democrat, but he said that his view now is that basically they were just pushing forward with things, without the kind of accountability. And if you read Ambedkar's letter of resignation from the cabinet, it speaks to that as well, that, there isn't that, ability to influence policy in the way that there was in the Constituent Assembly. And, we have a very
Let me
polarized.
take a few more questions because they're piling up, and
Yeah,
maybe
okay.
I can weave them.
Sure.
So this one says the reason for placing many land reform laws in the ninth schedule was to protect them from being challenged by large landowners and undermining the initial purpose of land reform. Is that not the case? I saw
Yeah.
that. Ms. Beena Agarwal wants to come in and ask. She's
You
on
can just
Zoom.
read the questions, yeah.
There is no question. She wants to say that she wants to say something. So we can allow that. I mean, shall I
think
read
she
the
can just
question?
type her question.
Okay, then ask it.
Yeah.
Right. And I think I've asked that question already, no? In the light of the recent SC decision, what in your view is the best mechanism to rebuild dilapidated multi-storied housing societies? But this is another relevant question. Do we have data on how individual high courts have historically treated this debate on property rights and development? And if so, do we see any extreme outliers in that regard?
Yeah.
I think her question was, I think she says there's some inaccuracies as illustrated examples. Economists do define property rights as a bundle of rights. Land reform was undertaken globally in the 1920s to the 1950s across socialist regimes, and 1950s to 1960s across non-socialist post-colonial countries like Asia, Africa, Latin America. And development is not just a utilitarian discourse. Then it says the HSAA 2005 overrode discriminatory land reform laws vis-a-vis women. These are the 4 points.
Right. So, so I think I've already answered the point about development, because that was your question also on development is not just a utilitarian discourse.
She's also adding that immovable property, again, is not just about legal rights. Economically, of course, it is very productive, but politically, it gives people citizenship and identity.
Absolutely. So Beenaji, thank you for your questions. I completely agree with you on the last point. And, I think that was a comment about how land reforms were undertaken in different parts of the world.
Yeah.
That was the consensus of the agenda. I don't think I have claimed, and I've said this repeatedly, that there was diversity of thought within the dominant development paradigm. I mean, I've mentioned Alexander Chayanov, I mentioned Charan Singh, and Gandhiji himself on what his idea of development was, which was different from the dominant idea. But these, in terms of reviewing the policies of the state, the industrial policy, and the things that were actually implemented, like I did right now with the current land measures, whether it's the digitization of land reforms program, the Swamitwa scheme, and so many other schemes that the government is implementing right now, which come from this dystopian idea of property rights. And of course, even within I'm sure that certain economists do understand property as a bundle of rights, but the new institutional economics people that I was talking about, that David Kennedy critiques in his essay on some caution about property rights as a recipe of economic development, AJR, the way they talk about secure property rights, it's not at all clear to me that they are including indigenous people's rights as property rights. That's not how they're looking at that. So of course, I'm not claiming that this is the only view, and Beenaji's view is probably much more nuanced, but this has been a dominant view which has influenced the economic development discourse, but also policy in India. I think there were too many questions, so I don't know. The Hindu Succession Act removed anti-discriminatory provisions, but with respect to agricultural land, as I mentioned, in some states, there are still discriminatory clauses, which between various grades of heirs, and within those grades of heirs, there are still discriminations between married daughters and unmarried daughters. So it's not about women versus men anymore necessarily, but there is still discriminatory clauses with respect to. Sorry, did I miss your question? Yeah.
He hasn't asked his question yet.
Yeah.
We'll take these three and then another one.
Yeah.
Okay, yeah. Ma'am, so my question was actually more coming from like a more economics point of view. In land rights, like how do you see the trade-off between economic equity and efficiency playing out in and like given the tension between market-based reforms and political pressure for redistribution? I mean, like from a legal standpoint, are like current laws and frameworks adequate to balance these priorities, or do they like in a way perpetuate historical inequity?
So actually, my entire body of work has been about showing that equity is important to efficiency. Because what I always say is that if you want to ram certain projects through which are inequitable, but merely because they are efficient, for example, with like what happened to Costco or with what happened to Vedanta, like stalled investment is no investment at all. So if you think that this project is going to be efficient and bring about growth, but you don't consider the dignitarian aspects, it leads to protests on the ground, it leads to opposition in the courts, and then it gets stalled, then stalled development is no development. So I don't think efficiency can ever be achieved without equity, because if you kind of push your will through, there might be resistance, and then ultimately it doesn't necessarily translate into an efficient outcome if you are meeting constant resistance and halogen. So it's important to build in equity concerns within that, and that's why I'm trying to bridge these two discourses together. Because I completely agree with you, Shahrukh, the development discourse doesn't need to be utilitarian, but often it is. Even if you look at the language of the court, and we've just been looking at judgments with, now there is a right to development that India and China especially have pushed on the international plane and within our courts as well. Like, what does right to development mean? Because both concepts are so amorphous that you can put in everything there. And that's when these strands are dominant. So like development for like a housing complex in Mumbai versus a slum. Who is adding the meaning to those clauses, and what paradigms are they operating in?
Yeah.
And so that comes in there. So I think that's the main point, is that it's very context specific. And, I completely agree with you that we need more representation. The entire point is really about diversity of thought and representation, whether it is on the bench.
I understand now.
Whether
It's
it is-
your point really is about arbitrariness and inclusivity,
Yes.
right? And property rights is your field to sort of make that point.
I think that point can be made in many other fields. I think the problem in legal research often has been that we haven't looked at the entire volume of cases. We've looked at the most definitive ones because lawyers tend to do qualitative research. And what we have tried to do at the Land Rights Initiative is do this qualitative and quantitative research, look at large data sets of cases to see, okay, like who all were bringing these claims. And there are other scholars who have done that, like Rohit Ray talks about it in his book.
Yeah.
So, we had this discussion where I asked him, like, you talk about everything but property, and he says that yes, because you're talking about property. So, it's that, but he also brings out how like marginalized groups, in his case, the Muslim Qureshi butchers or the sex workers, or, people whose livelihoods have been illegalized. And my work is also showing something similar, because when your the licensing cases, which are a significant percentage, or the Essential Commodities Act, what is Essential Commodities Act? It was basically the government saying, and of course it is required, that this is an essential commodity, so you can't operate in it anymore. We are going to do it. But why do farmers commit suicides when onion prices are regulated, right? Because it has an impact on the way of.
I'm taking two
livelihood
more
in-
questions and
Yeah.
but
Just in response to what you said, also tell me what is the statistics in terms of pure land right cases? Who brings those cases to court? Mostly land rights. But I'll take your question and your
Yeah.
question.
Thank you, Chair. Ma'am, please pardon me, because I normally don't agree with the norms, the conventional talk. Now, we've been talking about the parliament, constitution, codes, laws and amendments. इसमें घूम के रह मैं हिंदी में बोलना चाहूँगा, हम इसी में फंस के रह गए हैं। हमने इसके इतिहास को नहीं देखा कि ये कहाँ से आया, कहाँ ये आज़ादी के बाद ये अब नहीं, ब्रिटिश काल में ज़्यादा, उससे पहले जो राजा थे वो और भी ज़्यादा करते थे। तो स्टेट, चर्च एंड द लैंड, इनका आपस में जोड़ है और ये एक दूसरे के बिना नहीं रह सकते। स्टेट भी नहीं जिंदा रह सकते, चर्च भी नहीं जिंदा रह सकता, ये सब उनका ही खेल है। और मैं ये कहना चाहता हूँ, आपने ये कहा कि जमींदारी इन अमेंडमेंट से और उन अमेंडमेंट से चली गई, जमींदारी पहले से भी स्ट्रांग हो गई है। अब ये माफिया, लैंड माफिया के हाथ में जा चुका है ये मसला।
that point she made.
This has been,
Makes that
now it's लैंड माफिया। दूसरा आप कहते हैं कि प्रोडक्शन जो है, जो लैंड राइट हम छोटे छोटे 2 बीघा 4 बीघा छोटे छोटे किसानों को दे देते हैं, देने से प्रोडक्शन बढ़ेगी। नहीं मैम, अगर इसको 100 एकड़ की लैंड में एक ट्रैक्टर चलता है, लैंड के मांड नहीं है, पानी की खाल नहीं है और घास फूस नहीं है, तो उसमें कई गुना ज्यादा प्रोडक्शन होती है। इसलिए कोऑपरेटिव जो है, बिग कोऑपरेटिव्स है, उनकी जो डिस्ट्रीब्यूशन ऑफ द लैंड प्रोडक्ट है वो फार्मर्स को दी जाती है, उनको मेंबर बनाया जाता है, तो प्रोडक्शन भी ज्यादा होगी, वो खुश भी ज्यादा रहेंगे और वो सुसाइड भी नहीं करेंगे। ये भी होगा। Right now.
That's a comment, sir. So we'll take 2 comments.
Yeah. So मेरा कहना, मैं एक में और कहना चाहूंगा।
नहीं,
आप
question,
एक में लास्ट मैं एक ऐसा एग्जांपल आपको देना चाहता हूँ। इस धरती पर सारे लैंड की जो बात करते हैं, सारी लैंड ट्राइबल के पास थी, आज उनके पास 0 है।
Thank you.
So, Namita, while you bring out the critique and the contestations extremely well, what I really missed, and this is similar to the point that Shahrukh made in our opening, comments on your presentation, is as an equally what I would broadly call the burden of proof, which is we definitely get the sensibilities with the critique and the idea. You've mentioned social movements. You talk about a whole set of cases that you are exploring in your studies. So what I would have ideally liked to see is a fleshing out of what Nancy Fraser would call has called as parallel discursive arenas, which is what essentially social movements are, right? So if that is the spirit in which you and I, some of us, look at this space, then the conceptual, fleshing out of that parallel discursive arena doesn't quite come through. One can get the sensibilities, as I said, the spirit of the argument. So a very quick illustrative example would be from below, the manner to the question one could ask is to what extent have these movements or these quote unquote parallel discursive arenas managed to to overthrow or create a space for themselves against vis-a-vis encroachments and a whole bunch of these resource extractivist interventionist projects. One example would be from next door Myanmar, a very interesting, fascinating example called the Land in Our Hands Network. Land in Our Hands Network, which for the first time brought together the first ever multi-ethnic grassroots movement, which brings together 60 organizations together from 14 states. And exactly as Nancy Fraser says, operates as a parallel discursive arena. It moves in tandem alongside, goes ahead and creates land policy from below, enforces it, creates a parallel space, successfully and is able to push back against and retain to this date. So it's a classic example, textbooks example of what you were trying. So some of those examples, if you were to bring, so the critique and the contestation one understands very clearly, but this,
All the examples from Latin America.
yes,
very
absolutely,
similar.
the Mapuche.
The Mapuche.
Thank you.
Okay, so I think you were basically making a few comments. I think there was a question there, but just to clarify once again, I am not saying, I'm saying exactly what you're saying in terms of the fact that the dispossession of the poor has happened more after property rights have been abolished. And that partly, if people remember the graphs that I shared, the percentage of development expenditure as a percentage of GDP is 20% now compared to like 3 or 4%. So it's actually the development, the more money you spend on development, and if development is understood as large dams, which Nehru considered the temples of modern India, and if you consider development as urbanization and industrial growth, which was the dominant development discourse during that period when the right to property was on the constitution, that was not necessarily going to conduce to the welfare of the people who were living on those lands that were taken over for the purposes of development without compensation or with minimal compensation. Also because the property rights within the Transfer of Property Act, even though it recognizes these bundles of rights, it's very hard to actually prove them through the evidentiary. We talked about burden of proof, the Evidence Act, and we had a talk earlier in this series about we have a new Evidence Act. So, but under the old Evidence Act, a legal document, the patta or a document is so related to the ability to prove your claim. So it's not as if the court would not recognize the claim per se, but that the burden of proof is so much, the evidentiary burden is so much higher for someone who does not have title, which is why the dispossession of forest dwellers that happened, because they didn't have those rights. And the work that has happened since the Forest Rights Act by the movements to actually talk about, to actually enforce and use geospatial mapping to actually show that these forest dwellers have those rights and so on. So, I think that is what I would say, that it's not the property rights itself, but the legal burden of proof that comes from all these other laws that also makes a difference as to what right can be proved and what right can be exercised. And the other points that you made were just comments about cooperatives and so on. I think different people have different views on that, and I don't think at all I have a view on how to repair dilapidated buildings. That's really not my area of expertise. So I'm just going to skip that as well. To your question, Dimi, actually, Nancy Fraser has this concepts of recognition and redistribution as sort of framing, the discussions around, a lot of her work, which has influenced our work on the Plural Lands project that I mentioned earlier, for which we studied the Vedanta case, which is the idea that recognition of these land rights. So there are instances where movements have sought recognition of their claims on land. That's the New Zealand Maori thing, which is actually very interesting, right? Because this is actually the original treaty between the Maoris and the Parliament and of New Zealand. And actually, it only recognizes the Maori community as separate compared to others. And what the Parliament is justifying this is that we are actually is equality. So, which is the point I've been making again and again, that none of these concepts is devoid of meaning. And I'm not batting for any one of them. I'm using the legal history to show you that this dominant narrative about property rights is incorrect. And the reason why we need to do that is because it's very easy to get rid of rights. It's very hard to get them back. And therefore, we need to understand what was exactly at stake in that. With respect to your second question about what does the data say about these land claims. Now, it is obviously the case. First of all, there's a huge volume of land litigation. Obviously, I'm not studying all of that. I can only speak to the 3,000 cases we looked at the land acquisition report. That, of course, because the 1894 Act only recognized title. So most of these claims were people who were brought by people who had title to the land, right? The 2013 law recognizes different kinds of rights. So you have different kind of litigation post the 2013 Act. With respect to the property rights cases, like I said, these cases were brought by property owners as well as livelihood losers. In the Sagir Ahmed case, for example, the case is by the UP, the bus operator, the owners, but also the operators. Everybody lost their jobs basically. And so, and so basically, that's why I said that the right to property, that the cases that were brought under right to property are now being brought under right to life as well, the livelihood cases. Because that was what was available. And so I have a very sort of, pragmatic view about law and rights, which is that the more tools that you have at your disposal to construct a claim, you can do it. I mean, the Vedanta case, which is a landmark judgment, because even the international standard is not a veto power. The Vedanta case, as you know, is where the Niyamgiri Hills, the court said that, the villages have a veto on whether this project moves forward. The international standard is free, prior, informed consent, but there is consultation and consent.
There's a question there. There's a specific question there.
Yeah.
It says, is there a role for international customary law, treaty law, and local customary law recognizing FPIC?
Absolutely. I mean, the thing is, the Vedanta case was above international customs, what I'm saying. So I'm saying that the Supreme Court, in moments of inspiration, just like Parliament, with passing the Forest Rights Act, is such an important legislation. And to Nimi's point, that came about through a social movement, right? So there is, of course, I can do another talk actually on the role of social movements in protecting land rights, because that is a big part of the work that we do. This talk was about the role of courts as providing a space for mediating those tensions by looking at a particular historical narrative, looking specifically at the data set of property rights cases. But as I mentioned, we are actually now doing another project where we are studying when social movements mobilize the law. So we looked at all cases where Adivasi communities brought claims as social movements, and we narrowed it down to 5 or 6 cases from so the Narmada Bachao Andolan case from Madhya Pradesh, the Vedanta case from Odisha, the Koil Karo Dam project from Jharkhand, and the Meghalaya Lafarge case, and the case I think did I say 4 or 5? But yeah. So I think which state am I missing? Starlight, no, we're studying one from Odisha. But in any event, it will. So the idea was exactly to see, because each of these states is different, right? Some are 5th scheduled states, some are 6th scheduled states. We used mining and dams because that has been the major, our scheduled areas work showed that mining and dams is the biggest cause of displacement. Like I said, dams were part of a development discourse, which, as Nehru said, dams are the temples of modern India. That discourse is what has legitimized the grabbing of land for these communities. And definitely it is social movements that
You are calling him a land grab.
I'll say what. So Jairam Relations Officer on Special Duty, Mohammad Khan, he spoke at the Land Conflict Watch conference, and he said something like, all governments covet land. So this is the claim that I'm making is not about Nehru specifically. I'm making a claim about government, about a dominant development idea. He's not the only one. He might have started the dams, but the dams have continued. We are building dams in the northeastern states now at a pace that never happened before, in the same way, in the same imagination. So yes, there may be different discourses, but we still are going with big dams, and big dams displace people and are also found to be environmentally perhaps not.
All
So
nations.
Srinivas is smiling, so he
All
may have
nations
other.
covered land, not just all governments. I think all nations covered land. But did you want to ask a question?
So he's an expert on water and dams and other things, and CPR has had a tradition of work on water and
Yes.
and dams. So
Well,
yeah.
there are 3 very quick questions. All of them you've actually answered. So I'm going to read them out if you want to add to it. And then there's a grand finale for a question, which I've saved for the end. So there are 4 in total. The first is a question from Sunil Kumar at the LSC. Could you say something about the proof of residence aspect of ownership, such as in the Forest Rights Act? This seems to me not to deny ownership rights, but to reposition it as a proof, which is difficult to prove. And you've touched upon this. The second is in the context of increasing land conversions and encroachments on agricultural lands and commons, can the principle of individual rights over personal capacity be treated as equivalent to or a substitute for property rights over land? How might constitutional frameworks address the tension between these rights while safeguarding environmental and communal interests? And the third is agency or the lack of it a useful lens or foundation to look at property? The issue of is agency or the lack of it a useful lens or foundation to look at property? Then issues of whether it is development / growth or some other paradigm for the treatment of property would fall away.
Development / growth, what?
Some other paradigm for the treatment of property would fall away. Just address the first part, I think. Is agency or the lack of it a useful lens or foundation to look at property? It is, I mean,
Yeah,
that's
he's-
exactly what we were talking about.
Exactly. I think the first two questions are similar in the sense that Forest Rights Act is a very pioneering law because it for the first time codifies in a way and it's a stronger law than PESA, for example, the Panchayat Extension to Scheduled Areas Act, individual and community rights to property, I would say, in the forest. So I don't specifically understand this point about proof of residence, but again, within that, even though the law protects both individual and community rights to the same extent, if you look at implementation, individual forest rights have been settled way more than community forest rights because our understanding of property is more about individual rights and less about community. But I don't see any reason why that needs to be our understanding of property rights. It has been the dominant understanding, but it can be changed. It wasn't the understanding before the British came in. There were multiple groups of people exercising rights. I talk about in this a paper of mine called Property and Sovereignty, Creating, Destroying and Resurrecting Property Rights in British India from 1600 to 1800. I talk about how, there were existing property rights, multiple groups exercising, and how the British changed that from 1600 to 1800. So it doesn't have to be. So that answers that. Of course, I think property is about power. Arbitrary action is about arbitrary exercise of power. Property holders wield power. Sovereign governments wield power. There is a classic essay by Morris Cohen called Property and Sovereignty, where he talks about how a property owner, insofar as he controls the lives of people who are like a business entrepreneur, if he controls the lives of people who are working under him, he's also like a sovereign. So property is not separate from that. And I think I completely agree with all of that. Development is also about power, right? If you have a particular conception of development where you privilege the rights to water of people in the cities and are okay with displacing people, whose lands the dams are going to be built on, if that is your moral compass, that, this is, and I talk about this in my paper on the human right to water, that while the human right to water has helped Dalits access water sources where they were discriminated against. So it works in a dignitarian way. It has worked against Adivasis. So to go back to that international customary law and understanding, it's a dialogue between the domestic and the international. The human right to water was only recognized internationally in 2010. I review all the water rights cases from before 1950, and I show that how the courts were carving out a right to water in India. And the Indian experience and experiences of other national jurisdictions has contributed to the international. Sometimes the international is ahead of us nationally. Sometimes the national is ahead internationally. It's a dialogue, but we always have to remember that there is contestation. And, so I completely agree with everyone who's saying that there is contestation, and I welcome the contestation to my views as well. I think contestation is good. We should not have one dominant paradigm. No, one nation, one idea is not a good thing.
Now, with 2 minutes to go, this is the last question that's come to us. It says, does Waqf Board play a role in land grabbing? Which, which is not even a real question.
Yeah,
But
I'm not sure. I can answer.
I was hoping that you'd use the last minute to clarify that one point. There is a narrative that says that if you take away property rights, it doesn't really help the most marginalized, the most poor, the most displaced people. And you said that you were contesting it, but can you clarify that? You
No,
mentioned this narrative and then, yeah.
Yeah, I'm agreeing with it in the particular context of this history, that taking away property rights has dispossessed the poor because, like I said, in the 1980s, and the effects of any particular regime, especially a regime like Indira Gandhi's regime, where basically she packed the courts, right?
So indirectly,
Sorry?
indirectly, it had.
Yeah, because what happened is that if you look at 1980s, right, from starting from Minerva Mills and like these cases, Sanjeev Coke and all that, where basically they're saying everything belongs to the material resources of the community. And then if you look at cases like Somvanti versus State of Punjab, where the court is saying that even 1 rupee per acre is okay. So for example, the land acquisition law has an urgency provision.
Yeah.
Now governments, when they have the urgency clause, they don't even need to apply the safeguards that are there.
No, but how does it affect the homeless, the displaced, the most poor? It will affect the middle classes, it will affect somebody. But why do you say that it affects the?
The homeless is a very urban conception.
No,
So-
you use that word. I think you were quoting Pratap Bhanu Mehta.
Yeah.
Displaced.
No, that no, what I was quoting was Pratap Bhanu.
Pratap's, the quote, I
Yeah.
just noted it, it says it.
Dispossession.
Dispossess.
Yes, dispossess.
Yes.
I mean, this is
Yeah.
paraphrasing.
Yeah.
But he uses the.
Dispossess.
Yes.
Dispossess the poor. And that I was saying is that why the view that I was quoting is attributed to him. And I was showing that different groups of people have now brought out this view, including movements that have agitated for land rights, like the Ekta Parishad, who have sought basically against this kind of state acquisition of land, which dispossesses the state. But homeless is a very urban classification. What Pratap was talking about was in the context of the land acquisition law debate that was going on. And what these movements have also talked about is about these land grabs and land acquisition, where people are not necessarily homeless. And that's why I keep repeating that land is so important. And we saw that with the COVID crisis when the migrants went home, because it is not just, it's not just an economic resource. It is shelter, it is livelihood, it is everything. So to that extent, when you weaken rights in such a way that it's possible to take away land for 1 rupee per acre, and then you've ousted the court's review in such a way that it legitimizes. I mean, we don't even get bubble gum for 1 rupee.
So it brings us back to the general thread in the narrative, that it all boils down to arbitrariness. And
Absolutely.
yeah.
And I mean, I think we see that in other instances. Bulldozer justice is about demolition of property, right? What are you using the bulldozers against? And yes, that person may be a criminal or whatever, but that doesn't justify you bulldozing their property. And if
Yeah.
you don't have property, and the Supreme Court has spoken very belatedly against this, right? Because it's so very hard to say anything against the government.
Thank you for that. Thank you. I'm going back a wiser person. Thank you very much.
Yes, of course.
You mentioned in response to my comment, Namita, about Nancy Fraser. I think her work on representation, compared to that, I think what I had in mind, which would be more suited for your work and the kind of argument you're making today, especially with reference to property or the access or the lack of it, would be her idea, her concept of this quote unquote subaltern counter public. So she talks about subaltern counter publics. And so there is a differentiation between the notion of the public and the notion of the counter public. So the contestation and what it adds up to. So some of that, theorization would be useful.
Thank you.
Thank you. I didn't realize I'm supposed to end at 5 o'clock. It's 5:30 already.
So we also are very, like you said, you come in, you said you have a, habit of coming, we also have habitual.
Late finishers.
Yes.
Yes, absolutely. Thank you.